Another mega trial, the Pizza Connection heroin trial in New York, lasted over 17 months. There were something like 21 defendants. The name of one defendant was not mentioned in the evidence or testimony until 6 months had elapsed. How does someone defend himself in a mega trial? How can a jury process evidence in a complex trial that takes 17 months and sort the truth from the lies in dozens of counts? How can due process of law be said to exist in that situation? Yet, these abuses are being tolerated in the prosecution of the war on drugs. The casualties include thousands of accused, including some who are innocent, with good defenses who rightly feared that the risk of conviction coupled with mandatory penalties made a negotiated guilty plea look more attractive. The Sixth Amendment, among many specific rights, guarantees that the accused shall enjoy the right to have the assistance of counsel for his defense. Yet even such a fundamental right is under attack by the government and the courts in the course of the war on drugs. In U.S. versus Morrison, Drug Enforcement Administration agents knowingly met with the defendant without counsel being present to denigrate counsel's ability and threaten conviction, thus invading and undermining the lawyer-client relationship. Yet the Supreme Court said a Sixth Amendment violation could not be established without a showing of prejudice to the outcome, in effect requiring the defendant to lose, thus weakening the protection of an individual's right to counsel. Congress has also joined the assault on the right to counsel. It gave prosecutors the power to seize the fees of the attorneys who represented the accused in drug cases. Justice Blackmun, in describing this law, said, "Had it been Congress's express aim to undermine the adversary system as we know it, it could hardly have found a better engine of destruction than attorney's fee forfeiture." Another frightening example is that the government is subpoenaing attorneys to testify against their clients in drug cases. This is the background. Under the Currency and Foreign Transaction Reporting Act of 1970, also known as the Bank Secrecy Act, if you went to a bank and made a $10,000 or larger cash transaction, the bank had to report that transaction to the Treasury Department. But if you bought a large ticket item like a car and paid cash, that did not have to be reported to Treasury. Now the Internal Revenue Code of 1986 requires all such cash transactions to be reported to IRS. It enables the government to get intelligence about people who buy a Mercedes with $55,000 in cash. Then the government applied this reporting requirement to criminal defense lawyers. The return requires extensive detailing of who the client is and the nature of the transaction. Look at how this works for lawyers and their prospective client. Let's assume that you believe that you may be under surveillance or investigation by the government. You keep hearing mysterious clicks on your telephone and you think you are being followed. You go to a famous criminal defense lawyer for advice and possible representation, and she wants $10,000, by no means an unheard of fee. You borrow a few $1,000s from 3 or 4 close friends and relatives. You pawn your stereo and pay the attorney the $10,000 in cash you've collected. The attorney, however, sends the required form to the Internal Revenue Service about you. You haven't been indicted. You don't even know if you are being investigated. Your attorney sends government investigators a form saying, "My name is Mary Smith, famous criminal defense lawyer. I've just been retained by Mr. Jones, who paid me $10,000 in cash to represent him."